Yes, welcome friends. We'll be discussing on Companies Act 2013. It is a mother of all acts. Of course, we have Contract Act, which we can say it is a forefather of all acts. But Companies Act is the most relevant today, keeping in mind the outburst of the private limited companies and the startups and so many other listed companies, stock exchange transactions. The world is heading towards more commerciality. Then why Companies Act also becomes important is it's a form of organization where it is legally monitored by the government. For that matter, any country, there will be a Companies Act which monitors how to register a company, what are the legal requirements for the company, and how the company should operate in sense, the compliance part of it. For all these things, we have an act called Companies Act 2013. Formerly, it was called as Companies Act 1956, which had 648 sections. 648 sections. When I say sections, please do remember that when we have sections, we have subsections, we have clauses, we have subclauses. So all that 658 sections in 1956 Act was replaced by Companies Act 2013. There are currently 484 sections. For our present scenario, what we are discussing, we will be discussing the basics of Companies Act 2013. Are we clear? Now, what do we learn in Companies Act 2013? First and foremost, whether a company is an organization. Yes, it is an organization. Whether it has any legal standing. Yes, it has a legal standing. Under which department of government is it monitored? It comes under Department of Corporate Affairs. Department of Corporate Affairs. There's something called Ministry of Corporate Affairs also. So these issues related to the company will be monitored by them. Which means the Act gives you sections right from how to incorporate a private limited company to how to incorporate a public limited company, what is the role of the directors, what is the responsibility of directors, what is the role of the shareholders, what is the relationship between the shareholder and the company, until the depth of the company, the provisions of law are being elaborately given under Companies Act 1956. Earlier, now Companies Act 2013. Let's try to understand the meaning of it. Section 2, subsection 20 of Companies Act 2013. Henceforth, if I am talking about Companies Act 2013, I will be referring it to as the Act to make it simpler. So section 2 bracket 20, or should I say section 2 subsection 20 of the Act defines or explains the meaning of company. What does it mean? Company means if it is incorporated under this Act. This Act means what? Companies Act 2013 or any previous law. If we take an example of Tata's, Birla's, Infosys, then Wipro, these were all companies which were there even before 2013. If these companies existed even before 2013, there should have been some law which should have told how the company should have registered and what and all protocols the company had to follow. If you see the Tata Group, it has 100 years history. That means 100 years back also there should have been an act which talks about companies. So any company which is incorporated under this Act of 2013 or under any other previous laws, then we can call that as a company within the meaning of section 2 subsection 20. Are we clear on this? Now, what are the features? This could be expected as a standard question in your examination. It could come as features of the company. Please explain the features of the company. They are basically 1, 2, 3, 4 and 5. 5 features which is the most important and the foundation of understanding what the company means. The first of the features that we'll be discussing today is it is a separate legal entity. Like how I am an entity in terms of having life, having heartbeat, having mind, having ability to think, rationally. I can file a case on someone, someone can file a case on me, I can go take loans, I can issue or give loans, I can purchase asset, I can assume liabilities. It is a separate legal entity. That means when we are testing the concept of company, we should just check whether is it capable of entering into contract. If you have read in Contract Act 1872, it should not be a person disqualified by law. For your contract to be valid, which was the essentials of the valid essentials of a contract, point to be noted is if the company did not have a separate legal entity status, then it cannot enter into a contract. As simple as that. So the first point is it is a separate legal entity. Under that, what are we trying to understand? Is there any difference between a company and a shareholder? Yes. Sir, basically what we understand is the shareholders will contribute money in the form of equity share capital, and the company uses that money, runs the show, and if profits are made, it gives back to the shareholders. Ultimately, the owners of the company are shareholders, correct, but shareholders are different, company is different. Meaning, let's say the company was incorporated, shareholders came and contributed their share capital, application money, allotment money, first call money, final call money, whatever it is. Finally, there was in the balance sheet, liability side equity share capital, asset side bank balance. Now the company is registered. If this bank balance have to be utilized, let's say the company wants to go and buy a property. Now should I ask the shareholder, shall I go and buy the property, or the company will take its own independent decision? Its own independent decision. That is why we say difference between the company and other forms of organization is for a company to take its own decision, it will rely on something called directors of the company, which I will come to it in the second or third point. There is a requirement of human being who runs the show. But when the company assigns this responsibility to director and the director goes and purchases the property, it doesn't become the property of the director. It becomes the property of the company. Which means company can own a building, company can give it on rent. If like you and me can own a building and give it on rent, the same meaning works for a company. Vis-a-vis that, if you see the other forms of organization, what basic other forms of organization do we know? Let's say a sole proprietorship, a partnership firm, and a company. Different forms of organizations are there, like a NGO, understanding? Then a trust, different forms of organizations are there. Let's take at the elementary stage, a company and an individual. An individual who is running a sole proprietorship business. Morning he thinks that, okay, I'll go buy from the market. He goes, buys from the market. He sells it. He makes his profit. That's how simple a sole proprietor's business is. But when it comes to a company, it's first a legal entity. Its decisions are taken through board of directors. The board of directors will execute the decisions of the company, and let's say they purchase the property. It becomes the property of the company. Now, an individual, he goes and buys it, meaning what? If an individual goes and buys a property, it is his property. Whereas a director is going and buying the property on behalf of the company. It doesn't become the property of the director, it becomes the property of the company. Understanding the difference? Second, if you have to observe, in the form of a partnership firm, partners are not called employees of the partnership firm, partners are called owners of the partnership firm. If a partner goes and buys property in his personal name, that is his property. Whereas if he buys the property in the firm's name, then only it becomes firm's property. Understanding what I am saying? If a director goes and buys property in his name, then also it becomes the property of the company. I am not telling his personal transactions, I am telling utilizing the company's funds. If the director goes and buys the property, it becomes the property of company. Whereas if you observe in partnership firm, what happens? If a partner goes and buys property by utilizing the funds of the firm also, we can do the routing through drawings. Partner has withdrawn the money, used that money, gone ahead, purchased the property, it is his property. It does not become firm's property. Essentially, you are understanding the difference? So, unlike other forms of organization, there is a difference between a company, which is a separate legal entity, and different forms of organization like partnership firms, sole proprietorship, etc. Next point of discussion comes where we say shareholders are different and company is different. This is an elaboration of what I am trying to tell from that time. Shareholders contributed money. They are the owners of the money. They are the owners of the money only. They are not the owners of the property of the company. That means if the property is purchased by the company utilizing this money, shareholders don't become the owners of such property. They are the owners of money. They are the owners of the company. Agreed. But if the company has utilized this money and purchased a property or entered into any contracts, the benefits or outcome of which will be only in the name of the company and not mentioned to shareholders. Further, what point of discussion can come here? If the shareholders are different from the company, can the shareholder enter into a contract with the company? Yes, why not? Because shareholder is different, company is different. In the eyes of law, company is one person, shareholder is another person. There is no bar or there is no limitation or there is no ban whatsoever for a person to enter into contract with the company. There might be certain compliances requirements of reporting, that is different issue, that becomes audit matter. If a shareholder has entered into a transaction with the company, the statutory auditor of the company has to report the same in his audit report. That is fair enough. But that is not meaning to say a shareholder cannot enter into a contract with the company. Now just think, can a partner enter into a contract with a partnership firm? That's exactly what I'm trying to tell. There lies the difference. A partner in his individual capacity cannot enter into a contract with a partnership firm, whereas a shareholder in his individual capacity can enter into a contract with the company. So very clearly, shareholders are different and company is different. Which means what? Who are these shareholders? These shareholders are those shareholders who have entered into or come into the company by virtue of something called Memorandum of Association. Sir, what is Memorandum of Association? When that topic comes, I'll elaborately discuss it. But as of now, what do we understand by MOA? Memorandum of Association means it is a mother document of a company. Sir, can you please explain what is mother document of the company? Like for a partnership firm, partnership deed becomes the mother document. For a company, the mother document is Memorandum of Association. We have 5 clauses under that. When we come to MOA, I will give a detailed discussion about it. It will have capital clause, it will have liability clause, it will have place clause. All these clauses are there. When we come to MOA, I will discuss in detail. So, any member who participates or comes into the MOA becomes the shareholder. Even though he is the shareholder, he is different, company is different. Check this. Shareholders would have subscribed to the MOA, but still company is different in the eyes of law. In the eyes of law, company is totally different, shareholder is totally different. Are we clear on this? So that was about the first point called separate legal entity. Now we move on to we have continuation of it. Under separate legal entity, we have few more things, which although I have covered it, it means even a shareholder can enter into a contract with the company. This is exactly what I told you. Further, in simple words, company can own, enjoy, sell property in its own name, even though the shareholders contributed the capital. This is also covered as points. I've written it for the purpose of exams. If you present it this way with little more elaborate explanation, marks will be assured, not to worry about it. A popular case law in the form of Macaura versus Northern Assurance Company Limited. Macaura versus Northern Assurance Company Limited, where Northern Assurance Company Limited is a company, Macaura is, let's say, an individual. The case law's outcome is any individual who is a member of the shareholder does not have any right in the asset of the company. That is the outcome. Check this. Shareholders will not have interest in the company. Interest, I mean what? The rights of if the property is belonging to the company, the shareholder will not have any rights in that property. The shareholder will have rights only in their equity share capital. Their rights is they are the owners of the company. They come to annual general meeting, give their votes in favor or against, entitled for dividends, and so on and so forth. But if a company has purchased any property, the shareholders will not have any interest in such property. They cannot have any interest in the property because the company is a separate legal entity. Are we clear on this? So that was about the first point called separate legal entity. Now we move on to the second point. What is the second point? Perpetual succession. I remember during PUC days, my teacher used to tell this: shareholders may come, shareholders may go, but company lives forever. Perpetual means forever. Forever in the eyes of law is not meaning eternity. It will get closed at some point of time in the form of liquidation. If the company goes for liquidation, then only it gets closed. Till it closes, shareholders may die or change. The company lives till it is wound up. So, the law has created this company. The law only has to kill this company. Kill in sense, not literally, I mean to kill, but the existence of the company came due to a process of law. The death of the company also has to happen by virtue of the process of law. Are we clear on this? Which means, in such company, any shareholder who may purchase the shares of the company, he may die. If he dies, his shares gets passed on to the successors. They are legal representatives of such shareholder. Such a legal representative becomes shareholder, which means even if shareholder dies, the shares are not dead, no. The shares continue to be there, shareholders continue to be there, shareholders may change hands, one person can sell the share to another person and go. Instead of this person being the shareholder, that person becomes a shareholder. So shareholders continue to be there or not. Company continues to be there till it is legally wound up. Wound up means when the death of the company happens in the eyes of law. Are we clear on this? Yes. It's treated as artificial person, so only law has to end the life of the company. The company is treated as artificial person. I am a real person. In the eyes of law, company is treated as artificial person. What is artificial person? Like we have robots. It is an artificial creation of mankind. It was not by birth or by virtue of God or by virtue of what we believe in the system of biology. So clearly understand, it is an artificial person in the eyes of law. If it is an artificial person in the eyes of law, the law only should end its life, meaning liquidation or in simple words called as winding off of the company. So an artificial person, so only law has to end its life. Death or insolvency of the shareholder will not make any difference to the company. If I am a shareholder, I have made investment in the company. If I die or if I become insolvent, it will not have any impact on the company. Company lives till it is wound up. Are we clear on these points? Alright, so the next point we go on is limited liability. Third point, which is one of the beautiful features. You will understand the advantages of limited liability. You will understand the advantages of company. If it is a sole proprietor, let's say he enters into a contract and he breaches the contract. There's claim of damages. Now can he say, this business has to pay the damages, I will not pay? He was a sole proprietor. If he is a sole proprietor, he is the person who has to take the complete responsibility. Understanding what I am saying? So he cannot say, business will pay. For accountancy treatment, we know that business is different, person is different. We are not looking at that. We are looking at the legal aspect. If I enter into a contract in my sole proprietorship capability, if there is damages, I only have to pay. I cannot tell business will pay. Similarly, if a partnership firm enters into a contract, understand this, if a partnership firm enters into a contract and there is a breach of such contract by the partnership firm which has led to compensation or damages, first the partnership firm has to pay the damages. Sir, what if partnership firm did not pay or was not in a position to pay? It filed for insolvency, it filed for liquidation. Then also liability is there on the heads of the partners in the individual capacity. When we go to Partnership Act 1932, we will see partners' liability is unlimited. It is called joint and several. Sir, what is this word joint and several? If partnership firm is not capable of clearing the liability, partners jointly have to clear that liability. If they are not capable of jointly clearing the liability, severally means joint and several. Several means individually at least they have to clear the liability. Sir, if let's say A, B and C were partners, partnership firm couldn't clear the liability of let's say 1 crore. then that 1 crore liability has to be cleared by A, B and C in their personal capacity. Let's say the ratio was 1:1:1. So A has to clear 33.33, B has to clear 33.33 and C has to clear the balance. Suppose A and B said, I don't have money, I don't have property, I don't have bank balance. C alone has to clear full amount of 1 crore because that is a compensation which is a liability. Sir, can you please elaborate that a little more? A and B, let's say, were normal persons of the society. They came, they had talent, okay. Business went on, but huge claim of compensation came. A told, I don't have any personal property. Maximum, I have my salary and my capital in my partnership firm. So that capital will go. B's capital also, let's assume it goes. They don't have any personal property. C, let's say his capital was 50 lakhs. A and B, gone. They have lifted half. Now, C has to forego his capital of 50 lakhs. A and B respectively also has to forego their capital. Let's say A and B had capital of 10 lakhs each. So they forego 10 lakhs of A, 10 lakhs of B and 50 lakhs of C. Gone. Now still 30 lakh shortage is there, no? Understanding what I am saying? C, assuming he has his personal house, car, whatever it is, he has to sell his personal property and clear the liability. Now why am I giving all this background? That concept is coming under and getting covered under the concept of unlimited liability concept. If a partnership firm, a sole proprietor is executing a transaction, he has in his mind that if and when there is a liability, it is unlimited. It can come and eat their personal assets also. In comparison with that, if it is a company which talks about limited liability, liability of the shareholder is limited to the share capital. Meaning maximum what the company can ask the shareholder to settle the liability. First, company only has to sell assets and settle the liability. By chance it is not having sufficient assets, and let's say the company has called up only 8 rupees share capital. Balance 2 rupees was there as final call. Maximum that the company can ask the shareholder to pay is at 2 rupees only per share into number of shares. No. Shareholders are the owners of the company, sir. Company's liability is, it has happened by virtue of breach of a contract. So company is telling, listen, I will sell all the assets. I got 100 lakhs, liability is 500 lakhs. I am hereby giving you 100 lakhs. This 400 lakhs is there. No. Go and ask the owners of the company. Who is the owners of the company? Shareholders are the owners of the company. If that is the scenario, shareholders will tell like this. Sorry, my liability is limited and restricted to my maximum share capital what I have contributed. Which means, if you want, you take my share capital and go. You can't come to my personal assets. Understanding the essential difference? In partnership firm, unlimited liability. In company form of an organization, the liability is limited to the extent of share capital. How much maximum that the shareholders can lose is only the share capital. Continuing, debts of the company are not the debts of the shareholder. This substantiates the point. This is the most beautiful point. Yes, if the company has borrowed loan from a bank, it is the company's responsibility to repay it, not the shareholders. Clear? Whereas we have some 2 points which makes a little bit tricky, or we are going a little bit away from this concept of limited liability. What is it? We can have other two forms of company. Now next session I will be discussing different types of companies. There you will see limited liability company, okay, then unlimited liability company, then company limited by guarantee. 2 such organizations I have taken here. Company limited by guarantee. What happens here? Company issues shares. Company will tell, okay, listen shareholders, we are taking up a project, but the project is demanding liability clause to be guaranteed by the shareholders. That means if the company is not able to pay, the shareholders have to give a guarantee. That is called company limited by guarantee. Company limited by shares means shareholder is telling my liability is maximum to the extent of share capital. Company is limited by guarantee means what? If the shareholders have given a guarantee amount, meaning what? If the company is failing in their obligation to repay this debt, shareholders in their individual capacity has given guarantee, then to the extent of guarantee, liability will come. There also, please mark this words, it is not unlimited, it is limited to the extent of guarantee given. Suppose 1000 crores was the liability. Shareholder has given guarantee of only 10 crores. Their share capital will go, that is different. That we already know it. Apart from share capital, what else can go? Amount to the extent guaranteed by the shareholder. If the shareholder is guaranteed 10 crores, he will be liable to pay 10 crores, not 1000 crores. Are we clear on this? And the last part, but for an unlimited liability company, liability is obviously unlimited. Generally, people don't prefer an unlimited liability company because whatever activities company has done, its liability will all become the liability of the shareholders. So very rare we see unlimited liability coming into, unlimited liability companies being floated. In today's world, I don't see the necessity for an unlimited liability company, though it is part of your textbook and part of your exams. I have reported it. Now the next one is artificial legal person. I have already mentioned here, when we understood separate legal entity, I have mentioned that it is an artificial legal person. When we mentioned perpetual succession also, I have mentioned that it is an artificial legal person. That means that company is not biologically born. It is born by the virtue of or by the process of or law has created such a company. It is a creation by a process of law. Law creates the company and law only allows it to die according to the provisions given. All the rights are available. Meaning what? Since law has created this as a company, it has become artificial person in the eyes of law. Like what rights Lohit has, the same rights that company also will have. If Lohit wants to go and buy a property, so can the company also go and buy a property. If Lohit can raise a loan from the bank, so can the company raise a loan from the bank. If Lohit wants to enter into a contract in his individual capacity, so can the company also enter into individual capacity. But there are certain exceptions. What a company cannot do, it might look hilarious, but it sounds practical to me. A company cannot marry, like you and me who can marry. Company cannot marry. Company cannot take oath. What is taking on oath? You are seeing these movies where in the box where you enter the code, on Bhagavad Gita, Quran, Bible, you keep your hand and tell, I hereby say whatever statements I make is true, and the statements made by me are always true and remain to be true. That is promise, meaning company cannot take oath. Sir, if company is a party to a contract and that contract is in the court, who will take it? Who will take the oath? Oath statement will be taken by the director of the company who is acting on behalf of the company. Are we clear on this? Company cannot stand because it's an artificial person. In the eyes of law, it is a person, but physically it is not a person. So company cannot take oath. It cannot carry profession. Meaning, Lohit as a chartered accountant can carry his profession. He applies his mind, he applies his tax laws, he applies his GST knowledge, he applies Companies Act knowledge and helps the clients to save taxes or plan their finances. When it comes to company does not have its own mind. Company will not have a brain which talks about income tax for it. It only says, I have money, I am investing it through the directors and I am making money and giving profits to you. So, what cannot the company do? Company cannot marry, it cannot take on oath, it cannot carry a profession. It can carry a business. It can carry a business, it can carry on business, but it cannot carry on profession. That is why if you have seen Chartered Accountants Board, Chartered Accountant Office boards, you will never find so and so Chartered Accountants Private Limited, so and so Chartered Accountants Limited. Mine, for example, Lohit & Co. Chartered Accountants. I am a sole proprietor. If it is a partnership firm, Lohit & Co. partnership firm, maximum. Lohit & Co. Private Limited cannot happen. Why? Lohit & Co. Private Limited cannot practice or cannot profess. Understanding profession. Profession means what? It is the decisions taken by a professional which is backed by the Act of Parliament. Parliament gives me the power to sign the balance sheet through Chartered Accountants Act 1949. Similarly, if a company becomes the statutory auditor of another company, Can the company sign on behalf of another company? No, it is the individual only who is signing it. That individual only can do the professional practice. Company cannot do professional practice. Are we clear on this? Which means what? A company can own property, operate bank accounts, raise loans, it can sue another person, it can be sued, that means it can file a case on another person can file a case on the company, it can represent before authorities, it can appeal up to Supreme Court, and so on and so forth. Further, but it can act only through human beings who are called directors of the company. Yes, it is an artificial person. Yes, it is a separate legal entity. Yes, it has perpetual succession, but it does not have its own brain to think. Its decisions are based on, or the execution of it is based on what a human does. These humans who are heading the affairs or operations of the company, they are called directors of the company. Understanding what I am trying to tell? Next. Directors are not agents of the shareholders. Very clearly I am telling, the directors are executing the transaction which the company has told them to execute. It doesn't mean that directors are becoming agents of the shareholders. Shareholders are different, company is different. Are we clear on these points? Last point on common seal is, that is 1, 2, 3, 4, 5. Fifth point is one of the features of the company, common seal. Whenever I enter into a contract in individual capacity, what do? I sign. Like that. Does the company have hands to sign? No. So there has to be a seal. That seal is a mark that the company has authenticated the document. It's called company seal. What is the meaning of it? It's an official signature of the company. Like how I sign, if the company has put an official seal, it means it has signed. Are we clear on this? It is a symbol of incorporation. The moment I have put a seal, that means the company is already incorporated. Sir, can't we create seals and put just like that? No. Common seal, if you have observed certain documents, a seal will be embossed. In sense, you can feel that. On a document, if you feel it, it's not just a rubber seal. It will be a impact-based seal where you can feel that embossed thing, where you can touch and see the round seal, where certain bulginess would have happened over it. That is called common seal. Now, till 2006 and up to 2013 Act, this common seal part was somehow relevant, but post that, common seal is an option for the company. It need not always put the common seal and authenticate the document. It can ask the directors of the company or the company secretary of the company to authenticate the documents, which means the Companies Act 2013 read with Companies Amendment Act 2015, it says company's common seal is not mandatory. It is an option. If you want, you can put it. Otherwise, that contract or that document can be authenticated by the directors of the company or the company secretary if the company has hired a company secretary. So, these very basic features of the company. In our next session, we will be discussing one beautiful concept called lifting of corporate wheel. When the next session starts, you will understand lifting of corporate wheel. For this session, thank you so much.